Hi, this is Mary Jo from eXp Realty, and I am here today to talk about probate. I'm here with Jim Reichert of Reichert Law, who has had 43 years of experience. Many families are facing elder care. They have aging parents, either aging in place or someone died suddenly and they don't know what to do. So we think it's always a good idea to plan with anticipation. And there are a lot of things. They come to a real estate agent, and I wouldn't know. I would refer them to an attorney. So we're here with Jim Reichert, and he's going to answer a few questions for us. Jim, thanks so much for being here. And, just chatting, you gave me so much information. There were so many things I didn't even know. Can you explain exactly what is probate?
Sure. Thank you, Mary Jo. Probate is really just the process by which we change the name on an asset from the decedent to the living people. The will gives us guidance as to who that might be, but if there is no will, the Uniform Probate Code, which has been adopted by all 50 states, spells out who should receive a decedent's assets. But probate just supervises the process and makes sure that it's done according to the will or according to the probate code.
Can you define for us what is a personal representative and what they do?
Yes, this is a modern term. Personal representative comes from the Uniform Probate Code, and it describes the person who's in charge of the estate. In previous times, we used the term testator or testatrix, administrator, and these people are all personal representatives. They all do the same job, which is administer the estate, gather the assets, pay the bills, distribute the assets.
Executor is another term.
Yes, executor and executrix.
It's all the same. So how do families who inherit a home without a will, do they need an attorney to help them through this?
Depending on the title of the property. So there are some things that families can do before a person passes to make sure that their real estate is transferred with the least amount of difficulty. One of those things is to make sure that the title is held between spouses as joint tenants. That is, with the right of survivorship. Joint tenants, when one of them passes, the other one automatically inherits it without probate. There also, Mary Jo, is another document that can be used called a transfer on death deed, a TOD. And a transfer on death deed takes effect at the time the person passes, and the title is transferred to the person named in the TOD. You can change the TOD 10 times, or you can leave it alone once you record it. The only requirement for a TOD is that it must be in the public record before you die.
Well, when should a family start planning? An elder person.
The general rule among practitioners is that older individuals should begin planning for their estate once they reach their mid-50s, going into their 60s. One of the big reasons for this is that there's a 60-month, 5-year look-back rule if you go on to medical assistance. And under that rule, the government can look at assets that you transferred for less than full market value. You gave them to your children, you gave them away. Those assets then are counted against you even though you don't have them for medical assistance purposes. So planning 5 years in advance is not starting too soon.
And we never know.
And we never know.
Because some people get hit with an illness who've been healthy all their life. All of a sudden, boom, they have a terminal illness.
Or they can have a serious accident where
Yes.
they become mentally impaired and unable to work and care for themselves.
It's a good time, anywhere after the mid-50s. And
Yes.
I think we're going to have to talk.
We'll take care of you.
How long does the process take for probate?
Probate has a bad reputation for taking a long time, and it doesn't have to take a long time. Most probates are wrapped up within a year of the person's death. It can be wrapped up a lot sooner though, but the minimum requirement is 120 days. Most probates, when you start them, you're required to publish a notice to your creditors, and that notice says that within the next 120 days you can come forward with a claim. If you don't, then your claim is barred. And so that 120-day rule protects the estate from claimants who don't make their claims in a timely fashion.
Sometimes families will contact us to sell a property, and then it's for sale, but contingent on probate or contingent on the court defining assets or something like that. So if I have a buyer who's interested in that, I should prepare them for at least 120 days to wait?
Yes, I think that's a fair statement. The personal representative could sign a purchase agreement before the 120 days expire, but the actual transfer would have to wait. There are some other rules that would allow you to do it in less time, as little time as 30 days, but you have to invoke these rules in a certain fashion. But generally speaking, 120 days is the safe rule.
So how do families protect their assets? Let's say they, mom and dad passes, mom is older, and she may or may not understand what she needs to do. So let's say she goes into long-term care. What can a family do to protect everyone's assets?
And you're picking up where we left off when we were talking about that 60-month look-back rule, because if you've done things to prepare your estate and shift assets out of your estate, you don't have to worry when you end up in that nursing home situation or when you're receiving some sort of government aid, medical assistance, or the like. But that pre-planning is probably the best thing that families can do. And if their assets are such that they are not liquid assets, consultation with an elder care attorney would be appropriate, yes,
right.
Would be very helpful. Another thing people can do, though, to protect assets is some families prefer to use a trust to put assets in to transfer them to the next generation.
Can you explain that a little bit? I'm sure, I have a number of estates that are in a trust.
Yes, so a trust is a separate entity. It's just like another person. It's a vessel into which people can place their assets, and they can nominate the recipient of those assets as part of establishing that trust. So as a result, the title to the assets are transferred from the settlor of the trust, or the initiator of the trust, to the trust itself. And then the trust has named beneficiaries, including the settlor, the people who started the trust, but also their children or church or other entities that they want to get their assets. So all of that is set up during their lifetime and then takes place after their death.
So let's say somebody had a surprise death and the family didn't know what all of those assets and steps were. How could you explain to them what they need to do? How could you help them?
So oftentimes when families come to our office for assistance, one of the things that we task them with is simply getting an inventory of assets. And most people will know the big assets, the house, the car, that sort of thing, maybe the lake cabin. But they might not be aware of an investment account with a stockbroker or CDs with a financial institution. In those situations, we ask them to get a hold of their last tax return for the decedent and see what interest income was reported on that return, because oftentimes that will give you the footprints to trace back to the asset itself.
Oh, so the accountant might be a source of information.
Absolutely, yes.
Okay.
Yes.
That's good to know. What about when the deceased has unpaid debts?
Well, depending on the nature of the debts, some debts have a higher priority in probate than others do. So in probate, the priority is the expenses of last illness, the funeral, we have the attorney's fees and taxes. So the attorney's fees become a priority only because the estate won't get probated if the attorney's fees can't be paid out of the estate off the top. In most cases, the medical bills have gone through some sort of insurance process, whether it's Medicare or a supplemental insurance. But I ask my clients to review those bills and make sure that insurance has made the payments on those bills that they should make. That's one way of reducing expenses to the estate. Another way is if the estate does not have sufficient liquidity. That doesn't mean it isn't valuable, but it just doesn't have enough cash on hand. Right. Some of those bills may be negotiated down to less than their full amount.
Oh, terrific, terrific. Thank you, Jim. I really appreciate your being here. What else, well, I'm in your office, so thank you for letting me come here. What else should families know about probate or planning ahead for their elder families?
I think the best thing that families can do is encourage their parents and even the generation, the children, the generation of children, to do their wills. A will
Okay.
does not have to be complicated. The will questionnaire our office uses takes 15 minutes to fill out. Most people will put it aside, and the next day they won't change 5% of it. So under those circumstances, getting a will done is probably the best thing, the easiest thing that anybody can do.
So then they know where to allocate it. And especially if you have a big family, I've sat through estates where there are 3 or 4 children, which is one thing to negotiate. On the other hand, an 8-child family can have a few discussions over what mom and dad decided.
And if there's a will that's been done in advance and been shared in advance, oftentimes a lot of that friction is dissipated.
What about, we always see on TV, the surprise reading of the will. Is that a reality or is that fiction?
Well, generally speaking, most wills are not read in the fashion that you see on TV. Most of the time the will's been circulated among family members before the person even passed, but certainly after their passing. So as a result, I have to confess that in my 43 years of practice, I've only done one office will reading.
One. So TV's fiction.
It's fiction.
Right. Thank you so much. Where can people be in touch with you if they need your services?
Mary Jo, I office in downtown Minneapolis. My office address is 400 South 4th Street, suite number 1025. That's Minneapolis, Minnesota 55415. My phone number is 612-677-8332.
Thank you, Jim. And maybe we'll come back with more questions.
Good. Thank you, Mary Jo.
Thank you.